everyone. I'm Natalia Ouellette-Grice. I'm a real estate attorney here in the state of Florida, and let's talk about the top 5 cheap quiet title mistakes that I've seen and why they can be detrimental to you, to your business, and why you shouldn't go with cheap, because cheap is not actually there to protect you. Okay, so number 1, improper service. Improper service. This means that, when there's a quiet title suit, there's parties that need to be served. Improper service is kind of like the attempt to skip properly giving notice, either actual or constructive, to the parties. So improper service can be, like we had one attempt to serve this person in person, we couldn't find them, so now we're going to do a notice publication. Whoa. There needs to be a real, true, diligent search of the parties in order to meet the requirements of due process. Improper service can get your case undone. Number 2, improper parties. Why? Because the Florida statutes relating to tax deeds say who proper parties are to the proceedings. Those county liens, those county agencies, those county attempts to collect let's say child support things, those are not proper parties. They are protected under Florida statute as being superior and co-equal in essence to the tax deed. They don't get wiped out. They should not be named as parties in the proceedings. Number 3, improper venue. Oh, this is an attempt to go cheap. That just really goes wrong. Improper venue means it's not filed in the proper place. So sometimes I've seen these quiet title cases be filed in county court. Well, guess what? Quiet title cases should not be in county court. I know it's a cheaper filing fee, but they don't belong there. Under Florida statute, the circuit court is the one with original jurisdiction over matters involving title to property. Therefore, they have to be filed in the circuit court. Yes, it's a higher fee, but it's a requirement. Number 4, ignoring federal law. So many people try to serve the IRS because there's a federal tax lien involved, or the SBA because the SBA has a loan. It doesn't mean that you can't name them in a quiet title action suit. You can, but if you do not have a properly trained lawyer who knows the ins and outs of serving federal parties, ignoring federal law can get those cases to be undone as to the IRS and any of the other federal parties that you've named in the suit. And finally, number 5, default judgments. Default judgments are when, let's say nobody responded, it's all defaults, and then instead of presenting a legal argument to the court with a hearing, or through at least, the proper legal arguments presented, the cheap firms just submit a motion for default judgment, mail it to the judge, say this is how they're saving you months and months of things, and they get a default judgment entered. Except default judgments can be easily undone. They're very easy to challenge. And these are the ways in which everybody that's, affected by these improper and quiet title mistakes can come back and bite you in the butt. And there's 4 years to be able to do this from the moment that the tax deed is issued. So imagine putting yourself into the circumstances where for 4 years, for any one of these 5 mistakes, the people that are involved, those defendants, those parties, can come back and sue you.